When a business faces bankruptcy, one of the most pressing concerns is the obligation to settle outstanding debts, especially those owed to the state, such as taxes. Understanding how tax obligations are handled during bankruptcy proceedings is crucial for any company navigating this challenging process. According to Vietnamese law, specifically the Law on Tax Administration 2019 and the Law on Bankruptcy 2014, there are clear guidelines on how a business must address its tax debts when it is declared bankrupt. The process begins when a business, unable to meet its financial obligations, initiates bankruptcy procedures. At this stage, the company is required to disclose all outstanding debts, including those owed to the tax authorities. The Law on Tax Administration 2019, particularly Article 67, stipulates that businesses must fulfill their tax obligations in cases of dissolution, bankruptcy, or cessation of operations. This means that even when a company is undergoing bankruptcy, it is not exempt from settling its tax debts. However, the actual payment of these debts is governed by the order of priority set out in the Law on Bankruptcy 2014. Article 54 of the Law on Bankruptcy 2014 details the sequence in which a bankrupt company's assets are to be distributed among its creditors. The law establishes a strict order of priority to ensure fairness and transparency. The first priority is given to covering the cost of the bankruptcy proceedings themselves. These are the administrative expenses required to manage and process the bankruptcy case. Next in line are the unpaid wages, severance allowances, social insurance, and health insurance contributions owed to employees, as well as any other benefits stipulated in labor contracts or collective agreements. This reflects the law's intention to protect the rights and interests of workers who depend on the company for their livelihood. Following the settlement of employee-related debts, the next priority is given to debts that arise after the commencement of bankruptcy proceedings, provided these debts were incurred with the aim of restoring the business's operations. These may include loans or other financial obligations taken on in an attempt to rescue the company from collapse. Only after these three categories of debts have been addressed does the law require the company to settle its financial obligations to the state. This includes all outstanding taxes and other mandatory financial contributions to the government. If, after paying the higher priority debts, the company still has remaining assets, these must be used to pay off its tax debts. In some cases, however, the assets of the bankrupt company may not be sufficient to cover all debts. If, after paying the cost of the bankruptcy, employee-related debts, and post-bankruptcy debts, there are no assets left, the company is not required to pay its remaining tax debts. In such situations, the law allows for the tax debts to be written off, meaning the company is released from its tax obligations due to insolvency. It is important for businesses and their management teams to be aware of these legal provisions. They ensure that the process of settling debts during bankruptcy is conducted fairly, with clear protections for employees and a defined process for addressing obligations to the state. Companies should carefully review these regulations and, if necessary, seek professional advice to ensure compliance throughout the bankruptcy process. In summary, a company undergoing bankruptcy must fulfill its tax obligations, but only after settling higher priority debts as set out by law. If there are no assets left after these payments, the company's remaining tax debts may be canceled in accordance with legal provisions. Businesses are encouraged to consult the relevant laws for detailed guidance on this matter.